Welcome to University of Maryland Extension, Farmer Resources for COVID-19 Response.
This is a presentation on COVID-19 and the new requirements for paid sick leave. I'm Sarah Everhart, and I work for the Agriculture Law Education Initiative. We're a partnership of the Francis King Carey School of Law at the University of Maryland, Baltimore, the College of Agriculture and Natural Resources at the University of Maryland, and the School of Agriculture and Natural Sciences at the University of Maryland, Eastern Shore. This presentation is intended to provide general information and should not be construed as providing legal advice. The recently passed Families First Coronavirus Response Act requires employers to provide paid leave through two separate provisions: the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Expansion Act. Let's talk about the Emergency Paid Sick Leave Act. It applies to employers with fewer than 500 employees, and it requires that they provide sick leave if an employee is unable to work or telework because of the following circumstances: because the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. This has been interpreted to include stay-at-home orders and shelter-in-place orders. Also important to note that employees are not eligible to take this leave if the employer does not have work for the employee. And that might be a situation where, because of a stay-at-home order, an employer is not able to function and doesn't have the work to offer the employee. Other situations include if an employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19, if the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis, if the employee is caring for an individual subject to a federal, state, or local quarantine or isolation order, or has been advised by a healthcare provider to self-quarantine, if the employee is caring for a son or daughter whose school or place of care is closed or child care provider is unavailable because of COVID-19 precautions, or if the employee is experiencing substantially similar conditions as specified by the Secretary of Health and Human Services in consultation with the Secretaries of Labor and Treasury. All right, let's talk about the amount of sick leave. So for full-time employees, they're eligible for 2 weeks of paid sick leave, up to 80 hours. For part-time employees, the leave is in an amount equal to the average number of hours they typically work in a 2-week period. As you can see on the right-hand side of the slide, I've reprinted the reasons that I had just gone over in the previous slide. So for reasons 1, 2, and 3, paid sick leave is to be given at the regular rate in an amount not to exceed $511 per day or $5,110 in total. For reasons 4, 5, and 6, paid sick leave should be given at 2/3 of the employee's regular rate in an amount not to exceed $200 a day or $2,000 in total. All right, let's talk about the other type of leave. The Families First Act amended the Family Medical Leave Act to require an employer to provide qualified family leave wages when an employee is unable to work or telework due to a need to care for a child, if the child's school or place of care has been closed, or because the child's care provider is unavailable for reasons related to COVID-19. Now, typically agricultural employers don't need to worry about FMLA because FMLA only applies to those with 50 or more employees, and most farms don't have 50 or more employees. This recent revision, the expanded FMLA, applies to offices or places of business with 500 or less employees. So it greatly expanded the coverage. So most farms are now going to be subject to this expanded Family Medical Leave Act. What does it require? Well, the first 10 days or 2 working weeks are to be unpaid. And that's really because this leave was set up to work with the first type of leave that we talked about, the sick leave, and I'll describe that more in a minute. However, during that 10-day period, an employee is entitled to receive those qualified sick leave wages that we were just talking about, or other forms of paid leave available through the employer. Thereafter, the employer must provide the employee with family leave wages for up to 10 weeks. So it's 12 weeks in total with the sick leave and the family leave together. The leave wage is equal to 2/3 of the employee's regular pay up to $200 a day and $10,000 in the aggregate. So let's talk about how the sick leave and the family leave would work together. If an employee must care for his child whose school or place of care is closed or whose child care provider is unavailable due to COVID-19, the employee is entitled to qualified sick leave wages for the first 80 hours or 2 weeks, and thereafter would be entitled to family leave wages for up to an additional 10 weeks. The good news for employers is that they may claim payroll tax credits for the leave wages paid to employees for taking the paid sick leave or the expanded family medical leave between April 1st and December 31st, 2020. Employers can claim the credits on their federal employment tax returns or by reducing their federal employment tax deposits. Employers are also entitled to an additional credit based on costs of maintaining health insurance coverage for the eligible employees during the leave period. There is an exemption for small businesses, so employers with fewer than 50 employees may be eligible for an exemption from both of these types of leave when they have to provide the leave to care for a child whose school is closed or childcare is unavailable, when that leave would jeopardize the viability of the business as a going concern. So let's talk about what that means. Thankfully, we've gotten a bit more interpretive guidance from the Department of Labor as to when this exemption may be taken. So a small business is eligible for the exemption when such leave would cause the employer's expenses and financial obligations to exceed available business revenue and cause the employer to cease operating at a minimal capacity. Or when the absence of the employee requesting the leave would pose a substantial risk to the financial health or operational capacity of the employer because of the employee's specialized skills, knowledge of the business, or responsibilities. Or the employer cannot find enough other workers who are able, willing, and qualified and who will be available at the place needed to perform the labor services the employee requesting the leave provides, and the labor or services are needed for the employer to operate at a minimal capacity. So if any of these reasons are applicable to a small business employer, what they should do is document the reasons why they're eligible for these exemptions. The Department of Labor, this is not the type of exemption where you're going to apply and then receive word one way or the other from the Department of Labor. What they've instructed folks to do is document their eligibility for this and then retain that documentation. Employers have an obligation to inform their employees about all these new changes. So they must post and distribute the Department of Labor poster. I've provided you the link there to all employees by April 1st. An employer can satisfy this requirement by emailing or direct mailing the poster to employees or posting the notice on an employee information internal or external website. Employers have to keep all of the records related to granting or denying sick and family leave for 4 years. I provided you some links here for some more information on these topics for the sick and family leave and more specifically for the payroll tax credits. Anyone with questions can also contact me by email or by phone. Thank you.